For decades, Africa has been told that climate change is a scientific problem, a political problem, or even an economic problem. But now, for the first time, a court has said it is a legal one, and Kenya is right at the center of what happens next. In the last 12 months, something has shifted dramatically in how the world views climate change. It's no longer about melting ice caps or carbon targets or government sitting in some conference in some city far away. The conversation is now about the law. In July of 2025, the International Court of Justice, which is the highest court in the world, unanimously ruled that governments have a legal obligation to protect climate systems. And for a country like Kenya, that emits less than a tenth of the 1% of the global carbon emissions, that ruling matters because the country suffers serious climate impacts despite having very little to do with it, from flooding in the west to droughts in the north and to a sinking coastline. And so today we ask, are we actually ready for this? My name is Zena Bondati, and this is Earthwise. Kenya's climate reality is visible in the cracked earth of Turkana County, where 4 consecutive failed rain seasons in 2022 pushed millions of pastoralists to the edge. It is visible in the floods that swept through Tana River and Kisumu, displacing families who had lived in the same place for generations. It is visible in the coastline of Lamu, where communities whose ancestors fished these waters for centuries are watching the sea encroach. Kenya generates less than 0.1% of the global greenhouse gas emissions, yet its emissions have more than doubled since 1955, and without adaptation measures, climate change could cost Kenya up to 7% of GDP by 2050. The country that caused almost none of these crises is paying a devastating price for it. And for a long time, the only tools available to respond were political. Negotiations at the COP, pledges that were made and broken, voluntary finance that arrived late or not at all. But in the courtrooms, something is building. A body of environmental law constructed over 2 decades that is now positioned to become one of the most powerful tools for climate accountability on the continent. Justice Matthew Emukule is retired now, but his fingerprints are all over Kenya's environmental jurisprudence. In 2006, as a sitting High Court judge, he was part of a 3-judge bench that decided a seemingly small case, a dispute about sewage in a Kiserian township, in a way that would echo for 2 decades. It was Waweru versus the Republic ruling of 2006. Mm-hmm. You, along with Judges Nyamu and Ibrahim, because that kind of set the course for environmental litigation in Kenya. Can you tell us a little bit about that?
That was an interesting case because Waweru, according to the facts, had been charged with polluting the Gong River. Okay? So, and Waweru argument said, look, I had nowhere else to take effluent. Under the various principles, I think the real principle that the polluter pays, we say, look, it's really a duty of the state, of the citizens as a whole, represented by the state and government, to provide for these costly systems. So we found and established that instead really of punishing Waweru, we made declarations that it is the state that should carry out those functions. And indeed, after we passed that judgment, it was fortunate, this you not find in the judgment, it was fortunate that the minister for Kajiado North at that time was the vice president, Saitoti. Okay? Within about 6 months, resources had been mobilized for development of a sewerage system, water supplies within that Greater Ongata-Rongai area.
Okay, so the same case also introduced the concept of polluter pays principle,
Correct, yes.
which is a big deal in climate spaces.
Absolutely.
But it was the first time it was being heard in a Kenyan court.
Correct.
Did you anticipate the, what do you call it, the events after that people would start to quote the case and set the cause for environmental litigation in Kenya?
We did not anticipate that these other things would happen. Except this, to the extent that in my formative days, I was privy to the establishment of the enactment of the EMCA, that is Environmental Management Act of 1999. Didn't come into force, I think, until sometime 2000. Okay?
Mm.
And in that act, you'll find that your researcher will show you, direct you to section 3 of that act.
Mm.
It is incorporated in this constitution.
Mm.
It says that any person who believes that environment is being disturbed or being interfered with can go to court.
Okay, so since then a lot has changed and happened in the environmental space, both locally and internationally.
Correct.
And we've seen more and more people suing their governments because of climate-related impacts. And it's now a little bit over a year since the highest court in the world, International Court of Justice, issued an advisory opinion on climate change.
Correct.
And said governments can be held legally viable for the impacts as a result of climate change.
Correct.
You are now a retired judge, but you're still actively involved in climate litigation space. So when you read that advisory opinion, as a Kenyan jurist who spent decades on the bench yourself, what goes through your mind?
ICJ gave a very, very comprehensive opinion on the entire issue, because there were two issues. You know, the effects and the consequences of climate change and necessary financing for, I suppose you're going to ask me that question later, for breaches or non-honoring of the various obligations that states assume once they adopt or ratify these agreements or these treaties or these conventions. Yeah.
Okay. If you take this opinion as it is, the advisory opinion, is it enforceable? What would it take for a community here in Kenya, for instance, to use it to actually win?
I think the easy answer is that being an opinion, it is an opinion.
Therefore not legally binding.
It's not legally binding.
Okay.
But that's the easy answer. But the real answer is this, that so far as states, including Kenya for that matter, okay, have ratified through their local processes without any reservation the provisions of that treaty, convention or protocol, agreement, like a Paris Agreement, etc., it is binding. And you know, under the Kenya Constitution, international law, public international law, is part of our law. It is binding.
Yeah.
It was a moot court competition.
Brian Awonda is a different kind of environmental lawyer. He didn't just study the law. He decided to use it as a weapon, building an organization that is training the next generation of climate litigators across the continent. How is the ICJ opinion helping you in the cases you're already involved in?
Great. The ICJ advisory opinion is really crucial, number one, in as much as it is cogent or persuasive, but it has mentioned climate laws. It has mentioned pre-existing climate laws, which were there even before the advisory opinion. So according to me, in as much as they say advisory opinions are non-binding, I find this advisory opinion, one, binding. Number one, because it was requested by the General Assembly. And after that opinion was given, the General Assembly has
Adopted
passed a
it.
resolution to adopt it. So
And
that
Kenya
one,
supported
Kenya
that
supported it. So we are bound by it. And then there are also the pre-existential climate laws. For example, the laws on waste management, the laws on perhaps deforestation. All those laws are binding, but brought together, they formed the advisory opinion. So in as much as it is an opinion, it is binding. Yep.
And you're already
We
citing that
are citing
in
it. In
court.
fact, even in the climate litigation petition on behalf of farmers in Kisumu, we cited it. And when we came on record for the Nairobi Animal Orphanage case on behalf of Future Generations and Nature Rights, we also cited it, and it was one of the things that I believe made us to be enjoined as interested parties. Yeah.
For the farmers in Kisumu, how many farmers are there?
There were 5 farmers representing 600 of them. So they petitioned on behalf of 600 farmers. But you will find the petitioners in that case are large landowners. For example, you'll find Justice Emukule has 200 acres, Sembele has another 200 acres. And then, without prejudice, there's a prayer for loss and damage for 1 billion. And it has come like, it is, people are saying this is judicial activism, that we are not fighting climate change, that we are after the money. But the Supreme Court earlier last year actually, indicated that in a ruling, I just forgotten the citation, but indicated that the price of restoring degraded land that has been affected by climate change for an acre is 2 million. And that is now the law. So if
you add it up among the 600 farmers
who have all over 500 acres, then you find it becomes to 1 billion. So there's a danger with this petition in that, one, who is a farmer? Today I can just wake up and say I'm a farmer because I have a small garden. And then now it
but
comes...
the image of a farmer has changed. It's no longer somebody in tattered clothes, looking
Exactly.
so poor with a djembe.
Exactly. And if you look at the Black's Law Dictionary, it even indicates someone who is selling farming appliances
Is also
a farmer. So, using the government's database, when they were registering the fertilizers, farmers registered. The platform has almost, I think, 6 million farmers. Now, someone just asked me if these 6 million farmers would be enjoined to the petition. And then the cost of restoring 1 acre
is 2 million.
is 2 million. And then we decide, let us give all these petitioners, these farmers, 1 acre each. Then it is 12 trillion, 4 times the budget. So you find this is a petition which the government should take seriously because it has the effect of crippling the entire budget.
How far along are you in that process?
We're waiting for a judgment, and we hope for the best.
And one of the challenges that keeps coming up over and over and over is the threshold of evidence.
Yeah.
Without prejudicing the case, if we were to use another hypothetical situation, how, me as a farmer, if I want to sue the government some time down the line, what is the kind of evidence I need to be collecting?
To the contrary, what I would say is the Climate Change Act, together with the Constitution of Kenya, do not actually have indicated that there's consensus in the science. It is without say that the International Intergovernmental Panel on Climate Change has agreed that there is consensus in the science, and all this
everyone agrees the
in
climate is
it.
changing. Yes.
So what the law says is you need not to prove damage. You need not to prove the loss. Yeah, so long as you are just someone who can demonstrate that the climate effects have affected you in one way or another.
We saw a case of some farmers in Baringo bringing goats to court.
Yes. Those goats had eaten plants that
And
removed their teeth and all that.
Yes.
Actually, Justice Emukule was the judge in that matter. So you'll find they just brought it to persuade the court, but you know the burden of proof in environmental issues has already been done by the science. Yeah, so the science has already finished that. So
I don't need to have like a direct cause and effect.
Yes, because actually it has been said, if today you say you are a farmer and your farm has suffered the effects of drought, and you say it's because of climate change, that is it. Yep.
Okay.
Yeah.
So it's the threshold is much lower than we think.
It's much lower than we think. Yeah, it's much lower than we think.
As of 2026, at least 2,500 various cases are ongoing around the world on various climate litigation matters, including here in Kenya. And some have been concluded in various parts of the world whereby the governments have been held accountable. In Africa, 23 cases have been documented, and of those, 14 were filed between 2021 and 2025. The legal earthquake that struck in July of 2025 was decades in the making. It began with Pacific Island students in Vanuatu who campaigned for years to get the United Nations to ask the ICJ for a climate opinion. It gathered momentum through a series of national court victories in the Netherlands, in Germany, in Pakistan, and even in Colombia. The ICJ advisory opinion is expected to accelerate climate litigation between states, and Kenya was among the countries that pushed for the advisory opinion, driven by concerns that developed nations have been selectively applying international climate commitments while the crisis worsens. Kituo cha Sheria has provided legal advice to some of the most vulnerable Kenyans for 50 years, and now under Dr. Wambua Kituku, it is moving in a new direction, perhaps the most consequential direction on the African continent, looking at climate change, looking at environmental laws, and community rights against powerful developers. And this is because the organization's strategic plan, the 5-year strategic plan, centers climate justice as a key pillar in that strategy. And so to put this into perspective, Dr. Kituku is here with us to shed more light on this. And Dr. Kituku, first of all, welcome to Earthwise. I'd like to start with this strategy, this 5-year strategy.
Right.
All through, you've done legal aid for refugee rights, vulnerable people, legal clinics. You haven't really touched on environment, you haven't much touched on climate change before.
Yes.
So why now?
We had already started receiving complaints, issues relating to climate. Like for instance, when Lake Baringo waters surged, that led to displacement of communities living around the lake. And the communities felt that the government never did enough to help them grapple with that crisis. So we took up that complaint, we took it to court. It's now before the Environment and Land Court in now Nakuru, I think. It's been transferred to Nakuru. So that's a dispute that is connected to climate crisis.
Okay.
But before that, we also working on environmental issues that people are grappling with. Case dump sites, people complaining about illegal dump sites being operated by county governments within their neighborhoods, issues of community land.
We've seen around the world communities rising up and suing their governments about climate change.
Right.
And in most cases, we've seen these communities actually winning,
Yes.
and these governments being asked to take responsibility.
Right.
But the challenge, I don't know if you'd consider it a challenge, but how do you get this government to actually pay? If, for example,
Yes.
the communities, Baringo says they've counted their losses,
Right.
they've counted the damage, and
Right.
it amounts to 1 billion shillings,
Yes.
and they want to be compensated 1 billion shillings.
Right.
And the court actually says, yes, we actually agree,
Yes.
you are owed this 1 billion shillings.
Yes.
How do you collect?
You see, first, addressing the climate crisis is not just an obligation of our government. I think it's an obligation of the entire international community. So where our government is not able to live up to its obligations, then it's also under obligation to seek out support from the international community. So, and our government has been quite good at that. I mean, mobilizing climate finance all over, seeking international assistance whenever we have disasters. So by Kituo taking up these cases, suing the government to court, we're also putting pressure on our government to reach out to the international community and get this support. And we're also trying to make sure that when the government gets this support, it directs that support to where it's most needed. That is, those vulnerable, marginalized communities in this country. And there are quite many.
How do you prove that the government actually failed? Like, would somebody come and say, hey, Zainab, because you're a farmer, this is your land, you have 1 acre, a piece of land. Did you engage in climate smart practices? Did you do this? Did you do this? Did you do this? So do they look at all of my practices and then conclude, yes, here, I think somebody else was liable, not you?
Okay. It's up to the government to ensure that its citizens have all it takes to either adapt or have the necessary protection from this crisis. And also, the citizens have a right to participate in mitigation measures. That's reduction of emissions and things like that. So where those rights are violated, then people can go to court and hold the government accountable.
You submitted a brief to the African Court of Human and People's Rights,
Yes.
focusing on climate displacement.
Yes.
And there's also, is it part of that seeking an advisory opinion from the court?
That's right.
Tell me a bit about that.
So the advisory opinion was initially submitted more or less like a sequel to the advisory opinion that was before the International Court of Justice. But this one is specific to African governments. It's meant to interpret the obligations under the African Charter for people and human rights, which is a very progressive continental legislation. And so, but by the time that legislation was adopted by African governments, climate change was not, there was no much awareness about it, and there was no deep understanding about it. But because it's a dynamic law, so what the litigants in that case are trying to do is to see whether the African courts can interpret the obligations of government vis-a-vis that continental legislation.
Kenya voted for the UN resolution that requested the ICJ opinion and even participated in the ICJ process itself. And when the advisory came out in July of last year, it landed in a country that has a progressive constitution and a robust environment and lands court. But it also landed in a country where the access to justice is vastly different, and the difference between constitutional rights and communities' access to justice is vast. So Kenya is officially on board, but there is a difference between welcoming a ruling and being ready to act on it. And that difference is often measured in legal capacity, in how many lawyers understand climate law, in whether judges have been trained to apply it, in whether communities know their rights exist. Eric Theuri is one of Kenya's most prominent advocates. As the 50th president of the Law Society of Kenya, he led the legal profession through one of its most turbulent periods. In December 2025, he was conferred the rank of Senior Counsel, the highest honor in the Kenyan legal profession, and is now turning his attention to what he sees as the next legal frontier in the country, the intersection of climate and justice. You presided over the LSK at a time when the ICJ advisory opinion on climate came out. And there was a lot of excitement about it in the climate space. At that time when it came out, do you think the LSK prepared in any way to domesticate and actually use that opinion here in the country?
I would say it's more a question of a yes and no. Yes and no in the sense that there was no immediate reaction to it in terms of how it is used. But you must remember that decision is part of the persuasive law and authorities that come about with regards to environmental issues. And so it just builds on some of the decisions that our courts have given with regards to the question of protection
So it's
of
not
the
adding
environment.
anything
So it wasn't anything new. But as I've said, the more those decisions come, the more then you'll find that people are now questioning. For example, what has the government done? Because it has a responsibility as a result of that decision to protect the environment. What has the government done? Because we are feeling and we are seeing the impacts of climate change. The climate, the way we knew it, and the climate as it is right now in the country, there's been significant changes. And so there's been questions, what is happening? And you find that there is an increase in litigation, so that as people reflect more on that decision, then there is a lot of questions also on the government to just find out you have this obligation and this responsibility.
Do you remember back when a community in Baringo sued the government for suffering environmental impacts, and as evidence they brought goats to court, goats whose teeth had fallen out, and they told the judge, hey, look, this is what we are suffering as a result of government failure to tame the madenge weed. That's an example of the climate litigation cases that are going on here in Kenya. And as we conclude this episode of Earthwise, I hope we've not lost you in all the legal talk and all the conversations with the lawyers. And one thing I'm taking away from this episode, and I hope you picked up on it as well, is that the threshold of evidence is much lower than you think. And you just might be the next person standing before a judge suing your local administration. My name is Zena Bondati. See you again next week.